I want to talk to you guys about if you've lost your appeal, and obviously you've been denied benefits by Prudential, you've already done a voluntary second appeal, and we have other videos where we've talked about Prudential appeals and all of your different remedies there. But once the appeals are all done, you only have one remaining remedy, and that's to file a lawsuit. And Stephen, you can start off talking about what are the challenges of filing an ERISA lawsuit against Prudential versus the typical lawsuit that everybody sees on television, because this is a totally different world with a Prudential disability lawsuit.
This is an important aspect of it because litigating these cases is almost like another administrative review, right? So federal jurisdiction, you don't get the right to a jury trial. There's no live testimony, so you won't testify, your doctors won't, no one from Prudential will. And then the judge is tasked with almost, in my opinion, do another appeal review of sorts. So they're going to take a look at what your claim file is. That's anything you've ever submitted or is created from the beginning to the final denial. And then the judge reviews that, and ultimate decision is taking a look, one, did Prudential get it right? Is the person disabled? If the judge finds that there's not enough evidence of disability, case is over. If the judge does find that, no, the person's disabled, they got it wrong, it's then the second step, and that is, was Prudential arbitrary and capricious in the denial of the claim? And this is more of an idea of, did they have reasonable grounds, a reasonable basis to deny it?
In most cases.
In most cases. Now, there's some nuances to that, but I think that's like, a little, out there with legal argument as to the application of that. But if we say it as the standard, if that's the base that we're operating on. So in the event of final denials and filing of a lawsuit, your record's closed. It's not like in court and most people think, like you said, you're going to get to tell your story to a jury, you're going to call your witnesses, you're going to bring new information, look what happened to me. None of that exists, right? And the judge is really just tied to looking at this snippet in time. And realistically, even if your claim had been approved for a year or two, a couple of years, and then it's denied, it's still a matter of the most relevant for the judge is what's leading up to that denial, right? Because in Prudential is going to be like, yeah, we agreed prior he was disabled before, but here's why things have changed. So it's really kind of cold. And some people, since Prudential is going to require you to apply for Social Security, they think that's a hard process. But I always say, one day you might at least get to speak to an administrative law judge. Here, you're never going to talk to the judge. So it's a very just cold, methodical area of the law. So I don't think many people get the sense of vindication in their day of court when it comes to an ERISA case.
Right. And Caesar, I tell claimants when they call about their Prudential long-term disability denial and they have to file a lawsuit that this is a highly specialized area of law with very few attorneys who actually file lawsuits and have gone the distance with Prudential, have actually gone before a judge and know how to do a brief, and even if in exceptional circumstances have been able to get some discovery to show conflicts of interest with Prudential. But you only get this, again, this one bite of the apple. Although if you lose or win in federal court, which Stephen touched on, and I want you to talk about that, how this is federal court, because some people don't know, don't know the difference. There could be another level of appeal. So talk about the fact that this is in federal court, I think from a positive perspective.
Sure.
And then also like a time frame so people know what to expect.
Well, you got to remember, so federal court here, this is the judges, the federal court judges, U.S. District Court judges. These are judges appointed by the President of the United States. Whatever sitting president at the time had appointed this judge into their seat. They may be a new judge, never seen an ERISA case before. Which
we've seen, unfortunately.
Sure. It may be a judge with 40 years on the bench that never seen an ERISA case before.
Right.
But, they usually try to prepare and educate themselves very well on ERISA, the federal law. Okay. They have legal clerks, they have lawyers that work for the court, they have the legal briefs that we present to them, and remember the legal briefs that will be presented to them from Prudential as well on their defense side, that will be, essentially spelling out the law, spelling out the facts, making the arguments based on the laws and the facts. And Steve made a good point when he was talking about the standard of review that's often applied, and this abuse of discretion standard of review. And I, just breaking it down in layman's terms, it's what I call the benefit of the doubt standard of review. It's the court saying, well, the law requires us to give the benefit of the doubt here to Prudential that its decision was correct. And if, absent an abuse of that discretion, we got to uphold that decision. So lawyers like us fight tooth and nail to hopefully try to invalidate that abuse of discretion standard of review, whether it's saying, hey, the policy really doesn't grant them that discretion, or the law of that state has banned those clauses, or based on the evidence in the file or the limited discovery that we may have been allowed, they shouldn't be afforded this discretionary standard of review. So it's a real battle from start to end once it gets to that stage of the case, into that litigation in federal court.
So it's very technical, somewhat dry. It's not so cut and dry, but it requires an outstanding writing skills, ability to have the knowledge, which we have from having 13 lawyers who do this kind of work, of having read thousands of other court decisions. And there's been hundreds of other ERISA lawsuits, probably over 1,000 against Prudential, plus all the other companies out there all around the country. And you have to have that knowledge to be able to take that law, apply it to the facts of this case, to tell the judge, this is the law. Prudential's going to come, because it's the wild, wild west out there. They're going to come with all their cases and say, Judge, this is the law. At the end of the day, we try to get the judge to see the facts and focus on the facts our way and say this person's disabled. The last thing, which I just want to touch on, is that what's the remedy? What can you get out of this lawsuit, and how do they usually finish? And if you want to tackle that, Steve.
Well, I think remedy, everything in two ways. Federal courts do mandate mediations, so they are going to have formal sit-downs for Prudential and their attorneys, us and the client, to try to reach a resolution. And that goes back to even the appeal. The stronger your appeal, the information you build, the more value in the case, right? So there's that likelihood of settlement during. But if you do go take it to briefs and motions to the court and the judge sides with you, basically the judge can only award back benefits owed up to that date, with some caveats, like if they denied you in the own occupation period, they never reviewed for any occupation, a judge may be just limited to awarding the remainder of that and sending it back for further review. So a judge basically, in best case scenario, pay the money you owe up to date, put the person back on claim.
And then they have to deal with the company all over again?
Judge can't award future benefits, can't guarantee they won't mess with you again. There's no extra contractual damages. It's basically Prudential's worst day in court, maybe paying the money they owe you. Even when it comes to attorney's fees, it's at the discretion of the judge if it'll be awarded and then how much. So Prudential may not even have to pay your attorney's fees on it. So basically you win in court, get basically what's owed to you, and then you're just left back dealing with Prudential again.
And that is one of the biggest challenges, is that there's no extra contractual damages, which you touched upon, whereas in many other, if it wasn't governed by ERISA, you can go after them for extra contractual damages, like if you lost your house, if you lost your car, you could try to seek punitive damages to punish them for wrongful conduct. None of that exists, and literally every other person who calls us says, I want to go after them for punitive damages. And I say, I would love to go after them for punitive damages on every case where they acted inappropriately, but the law doesn't allow it, which is the reason why they were able to sell you a policy with premiums that are a fraction of the price of a policy that's not governed by ERISA. And the last thing in terms of a remedy, which you spoke about, was if you win, and you go through the whole thing. But 90% or more of these cases resolve either at the mediation that you spoke about or just prior to a briefing or something, and they result in a settlement. And those settlements, as you guys know, are these policies have a fixed value. And those settlements are going to be a percentage of the value. Your policy is worth X amount of dollars. We know how many months you're going to live, we don't know how many months you're going to live, but we know when the policy will end. So assuming you live to the end, which is usually age 65 or Social Security retirement age, times the amount of your monthly benefit, we know that dollar amount. We know how many years you have. So Prudential looks at it as a present value and say, how much is that in dollars today? We're willing to offer you X percentage of dollars. And we know that the stronger your case, the higher the offer. The stronger your law firm, the higher your offer. The chances of winning, obviously, is going to put more dollars on this case. So those are all variables. There's no hard and fast rule to say you're going to get 80 cents on the dollar, you're going to get 10 cents on the dollar. It really depends on the merits. And at the end of the day, us as the lawyers and the guide, we're going to say, here's what we think are your chances of winning. And whatever you say as the client is what we're going to go with. But if we think you have a loser, we're going to tell you. And if we think you have a winner, we're going to say push for it. We want to do whatever is best for the client. There's no pressure here. You are the captain. We're the boat. Just direct us where you want to go. We'll get you there. So people need to know there is that light at the end of the tunnel where you could get this lump sum of money and you're done. Complete divorce, you move on, and you don't roll the dice. And what happens often is Prudential puts enough money on the table where the claimant's like, do I want to risk it? And then I say it's like roulette. You pick red or black, because that's the chances. If you win, you could double or triple your money. But if you lose, you're going to get nothing. And we'll help you make that decision, obviously, so you make the right thing. So if you're someone out there with a Prudential long-term disability policy, feel free to reach out to myself, Caesar, Stephen, any of our lawyers. No matter where you live in the country, we're available to assist you. And we look forward to the opportunity to speak with you.